Hello and welcome back to the Appellate Practice and Procedure course at Solo Practice University. I'm Todd Smith, and if you watched the first class that we had, you've already been introduced to me and heard some of my background. I'm the instructor for this course. Today we're going to talk about our second topic, which is how appellate lawyers bring value at the trial court level. And so let's just get right into it. I have a slideshow. I think it's a SlideShare presentation that I converted from a PowerPoint. Just like in the first lesson, I have put this into the post where the lesson is, and so below this video you should be seeing a SlideShare presentation, and feel free to follow along with it, and it will help to illustrate some of the points that I'm going to be talking about today. So the first slide that you see is after the introductory slide is called an appellate lawyer's skill set, and we went over some of these issues in the first course, but just to review, I think this is a pretty accurate synopsis of what appellate lawyers bring to any particular situation, whether it be actually handling an appeal or writing trial briefs, which we're going to get into shortly, or that sort of thing. And so in sum, there are three basic skills that an appellate lawyer brings to the table in almost any situation. And they are the ability to research the law, do it efficiently and effectively, and find authorities that support or contradict the positions being taken in the trial court or in the appellate court, depending on the position that you're in, which side you're representing. Taking that law, once you've identified it, and applying it to facts. And the factual development is going to depend on what your court is. If it's a trial court, the facts are going to be probably in dispute. It's a rare case in which cases are tried on undisputed facts. But then if you're in the appellate court, then ordinarily the record is set and you are sort of stuck with the facts as they've been developed. Up until that stage, everything's sort of frozen at the point at which the record is put together. So, and then finally, as far as the third skill an appellate lawyer brings to the table, it is the ability to develop a persuasive argument favoring your client's position based on the law, having applied it to the facts. So let's see, going to the next slide, let's see, how do you effectively apply these skills in trial courts? And then, of course, a subsidiary question to that is, why would you want to? We're going to get into some of the details of what appellate lawyers can do to assist trial counsel at the trial court level, going all the way back to even potentially before the suit is filed. And but before we do that, let's talk about why you would want to do that as an appellate lawyer. Well, for one thing, it presents an opportunity to apply the skills that we just went over in a different setting. It adds some variety to the locations where you practice law. As most appellate lawyers, if that's all they do, they're making on average, maybe 4 court appearances a year. That being specifically in oral arguments before appellate courts, and that's probably a relatively high estimate. Me personally, I think in the last 12 months or so, I've had about 4 to 5 arguments. In the last 18 months, it's probably been more like 6 or 7. So even someone in my position who does this full time, if all I were doing was going and handling appeals and arguing those appeals as they were set for argument, I wouldn't have the opportunity to get down to the courthouse very often. And so applying your skills as an appellate lawyer in trial courts and assisting trial counsel definitely provides the opportunity to make additional court appearances in front of different judges, and largely using the same skill set that we've talked about earlier, but just applying it to a different setting. As a practical matter, it is just difficult to do nothing but sit down and research and write briefs all the time. Sitting in front of the computer screen, most of us do it most of the day as it is, but hopefully, we're getting out and getting exposed to different things, and getting out from behind the desk, so to speak, and avoiding that sort of sedentary lifestyle that comes along with largely being a lawyer, but particularly with being an appellate lawyer. You want to look for opportunities, I think, in order to make your practice more interesting, give it some variety, and also expose you to other potential sources of business. Working with trial lawyers leads to meeting other trial lawyers, and if you are able to demonstrate a good work product and a good presentation, you just never know when those trial lawyers that you either were up against in a particular case, or who happen to be in the courtroom observing you that day, might actually call you and hire you to work on one of their cases. And so all in all, basically, getting into trial courts to do work that supports trial lawyers is a really good way of adding some variety, to exposing yourself to new potential sources of business in the trial judges, which is very important. If you have the opportunity to get to know the trial judges, and all in all, just add a different aspect to your practice that would make it more interesting than it might be. And then finally, as a practical matter, doing appellate work, 8 hours a day, every day, and by that I mean, sitting behind the computer, or looking at Westlaw or Lexis or whatever your research tool is, reading a cold record, and just writing all the time. It's very mentally taxing. But the other thing that getting out and doing some different things does is gives you other opportunities to expand and manage and finance your practice. In other words, there are business opportunities out there for someone who's willing to look for them, and getting into trial courts is a way of doing that on lots of different levels. So, okay, so what's really the goal that you would have as an appellate lawyer getting out into trial courts? I mean, I'm assuming it requires a plaintiff to submit within a certain period of time. And so there's sort of a little cottage industry of appeals going on that are relating to issues surrounding those reports and the sufficiency of those reports to meet the statutory standards. And so, for the moment that you've managed to persuade trial counsel to hire you to come in and offer assistance at various levels, it could be, again, at the beginning of the case, middle of the case, end of the case. My view personally is the earlier the better, because the earlier the appellate lawyer has the opportunity to influence what's going on in the trial court, the better the potential outcome long term, especially if there is ultimately going to be an appeal. So moving to the next slide, I've kind of identified some issues. I think the basic function of an appellate lawyer in the trial court is to, if you want to sum it up in just one simple phrase, to position the case for appellate review if that's necessary. And so there are lots of different things that you can do to advance that cause. Obviously identifying potential issues that are appealable, or that may be appealable in the case, would be one of those. And that's more or less on a case-by-case basis. There's no generalizations that you can make with respect to that issue until you get into the facts of the case and understand what the legal issues are. There is the ability to look for broader patterns in what's going on in the appellate courts in your jurisdiction. So, I would suggest as a practical way of helping to sharpen your skills and stay more informed, keeping up with what's going on in the appellate courts. If you have intermediate courts in your state, the Supreme Court, or whatever the highest court of review in civil cases, or if you're doing criminal work, which is something I don't do, but certainly a criminal appellate work is a valid area of practice. Keep up with your state, whatever the state high court is that handles criminal jurisdiction. And I say it that way because I think I mentioned in the first video that Texas is one of, I believe, only two jurisdictions, Oklahoma being the other one, that has a split court system where we have a state Supreme Court who handles all civil appeals, and the Court of Criminal Appeals, which is the equivalent to the Supreme Court, but it has exclusively criminal jurisdiction. So look at the opinions coming out of those courts and try to stay ahead of the curve and evaluate or identify, I suppose would be a better word, issues that are seeming to pop up repeatedly. For example, we have here in Texas, we've gone through a big wave of tort reform in the last several years, and the legislature created a right of interlocutory appeal surrounding the expert reports that the statute, the Medical Liability Act. Now, if you're doing medical malpractice work, for example, monitoring those kinds of cases and knowing what the courts of appeals are doing in those areas would help you in terms of targeting new business from medical malpractice lawyers, whether it be on the plaintiff side or the defense side of the docket. It shows that you're truly an appellate practitioner when you have a sense of what's going on in the courts and you're proactive as opposed to being reactive to what goes on. And it's a constant challenge to do that because everybody has time restrictions and limitations, but it's well worth the investment to make that time to familiarize yourself with not only the courts and the judges themselves, but the opinions that are coming out from those courts. Third on this slide, we have developing the issues as needed to put the case in the best possible position if and when it goes up on appeal. I think that really is it in a nutshell, and we're going to get into some of the ways that you can do that as an appellate practitioner working with trial lawyers in the trial court. All of these activities are done from a different perspective than what the trial lawyer has. And this is really, aside from being able to comment and help shape issues, to me, this ability to evaluate a case from a more objective, dispassionate standpoint than the trial lawyer who has lived with it from day one, who has sort of a vested interest in seeing that the case is structured a certain way or comes out a certain way, or really wants a certain issue to work out as they want it to. Being able to offer the trial lawyer advice, having taken sort of a step back from that person's perspective, is extremely valuable, and good trial lawyers know this. One of the challenges in developing an appellate practice that includes litigation support type work, like what we're discussing today, is persuading appellate lawyers who don't have a real, trial lawyers who don't have a real appreciation for what an appellate lawyer can bring to the table, of what that value is and how it can help make them more effective in their own trials, and justifies the expense that they would incur or that their client would incur to bring you on board. So really the approach there is to try and provide counsel and the end client, whether it's an institution or an individual or whoever, with a view of the case that is more objective and, as I say in the slide, dispassionate, and frankly more like what the appellate court is going to, the view is more like what the appellate court is going to take when it reviews the case, because the appellate courts generally have no vested interest in the issues, and they're tasked with applying the law to the facts. And you can advise a client effectively as someone who isn't wrapped up in the case quite as tightly as the trial lawyer is. All right, so what areas do we have, what opportunities do we have to shape cases early in the case? As a general matter, an appellate lawyer appearing in the trial court or assisting behind the scenes, a trial lawyer has the ability to engage in some strategic planning or participate in strategic planning of the case, and analysis of various issues. A big area for participating at the trial level is preparing or responding to motions and submitting trial court briefing. That is a skill that, or that is an area where the appellate lawyer's skill is really tapped very effectively. Third, preparing the jury charge. This is an area where there's a lot of overlap with legal issues and potentially a lot of traps for trial lawyers who aren't focused on that issue appropriately, and we'll cover some details on that. And then finally, actually preserving error for appellate review, whether it be pre-trial, during the trial, or post-trial. All right, so let's talk about strategic planning and analysis. This can get you can get into any phase just about of the case and be able to offer, again, your unique perspective in ways that can impact the case in a positive way from your client's perspective. Even when it comes down to what legal theories to assert. Some lawyers don't, they get into the mindset of, well, this is a breach of contract case, I'm just going to assert breach of contract, whatever the basic theory may be. And maybe they haven't thought of a different claim like, fraud, or an action under your jurisdiction's version of what in Texas we have is called the Deceptive Trade Practices Act, which is really a consumer protection measure. Sometimes the trial lawyer doesn't think in a broader perspective, from a broader perspective, and bringing someone in to comment on the theories that are being developed might allow a broader development of theories. This also ties in to what I was saying earlier about keeping up with what's going on in your appellate courts in your jurisdictions, because quite often these theories will be discussed if someone else has developed a broad approach. They're presenting theories to the trial court and to the Court of Appeals in the alternative, and so you might have a case that discusses your basic cause of action on similar facts, but then also discusses to dispose of the appeal other causes of action that are alleged on that same set of facts, and that might help inform you and the trial lawyer, and ultimately the client, on what theories to plead or what defenses to plead. And defenses are just as important, of course. If you're representing the defense in a case and a defense is not pleaded, quite often that's going to be considered waived, and so it won't do any good for you to think of it on appeal. The client is going to be better off if you are involved earlier and can identify those issues in an earlier stage. Secondly here, discovery and participating in discovery sort of in the background, more than likely, is a good way of getting involved in strategic planning and analysis of cases. Again, you have an opportunity to get in and help shape the facts of the case in a way that supports the legal theories that trial counsel or you or the two of you together have developed. And if any of you have done trial work, you know that getting into depositions and getting into written discovery, you can develop a really narrow perspective very quickly, and it's very easy to overlook things that if you had more time or weren't distracted with something that your witness has said and trying to maybe do damage control, something like that, you would see these issues. But having someone who is a little bit detached and not necessarily getting embroiled in the heat of whatever the exchange is in discovery can be extremely valuable, because that person can help the trial lawyer channel their efforts back, or make sure and at least cover all the bases for other theories, other facts that need to be developed to support those theories. And also, if you become aware, and trial lawyers don't always do this, and I don't mean to lump all trial lawyers together, because that's not fair to do, and just like it's not fair to lump all appellate lawyers together. But if you have full disclosure of the what we usually call the warts in the case, or the weak points in the case, then you can help craft ways of de-emphasizing those weak points, just like you can help craft ways of emphasizing the strong points in a way that can really impact the outcome of the case. And so if I were going to speak to a trial lawyer and who had wanted to hire me to do some litigation support work like this, I would ask them, look, just like I do with a new client, generally, tell me everything, don't leave anything out, and allow me to come in and help you deal with straight up whatever the difficult issues are, so that you have a better chance of prevailing on those, and so that they don't come back and there's no surprise, or they don't bite you in the end. So discovery is definitely a ripe place for participating at the trial court level, and obviously that's these first two areas that we've discussed under strategic planning and analysis, legal theories and discovery, are generally they're pre-trial. So although legal theories can go on throughout trial and even post-trial, experts, the third item on this slide, is also generally a pre-trial activity. In Texas, the case law kind of lays out the circumstances under which an expert is required to prove a theory or defend a theory. And one way that an appellate lawyer can come in and add value at the trial court level is to advise the trial lawyer early in the case if he or she thinks there's a need for an expert witness to testify on say a technical issue. It's difficult. Trial lawyers are used to doing this, and so they, for the most part, probably have a good idea as to whether an expert's necessary. It's getting more and more expensive to litigate cases, and so some folks might be tempted to try and avoid going through the expense of hiring an expert. Having someone say, look, here's a case that says you need an expert to prove up this certain type of damages. Let's use lost profits for an example. You really can't prove up lost profits, Mr. Trial Lawyer, unless you have an expert witness. Having someone looking, I don't want to say looking over their shoulder, but assisting the trial lawyer is the way that I fall back on putting it. And advising the trial lawyer when that's necessary it would be very useful and potentially case saving, because if you get into an area where the deadline for designating experts has expired and the trial lawyer hasn't ever designated them because they didn't think it was necessary, then they could be out, and you can help as the litigation support person, the appellate lawyer working in the trial court, to avoid that outcome if you identify areas where experts are needed or even just helpful earlier in the case. And then also, of course, I've got here how to handle Daubert-like challenges. And for those of you who are French purists, forgive my pronunciation of what would otherwise be Daubert. But if you say Daubert in Texas, people will look at you funny. Kind of like if you say voir dire in Texas, people will not know what you're talking about, because here it's voir dire. And I didn't make this up, so that's our moment of levity for today's session. But dealing with expert witnesses, challenges to expert witnesses, is a critical area in the trial courts in which someone versed in the law of expert witnesses, the relevance and reliability requirements under the rules, and what it takes to get there in terms of establishing or challenging even expert witnesses can be extremely valuable. That is a big part of what an appellate lawyer can do in the trial court, is to handle these kinds of case dispositive issues, and we're going to talk about some more of those in a minute. Timing and the subject of various motions. Sometimes you, as the appellate lawyer in the trial court, will identify issues that the trial lawyer misses, not only from legal perspective or legal theories and the perspective of discovery or experts, but just in general. And you might figure out that, hey, we've got a potentially dispositive motion on limitations, for example, that the trial lawyer didn't identify. And so what you're able to do in that situation, and when I say you in this lecture today, I mean you as the appellate lawyer in the trial court, because I'd rather not have to come back and keep explaining that over and over. So just assume with me that that's what we're talking about. You as an appellate practitioner making an appearance in the trial court with a trial lawyer for the benefit of that person's client. You have the ability, as part of your analysis of the case, broader analysis of the case, to identify issues and to advise the client and the trial counsel on whether to file a particular motion, if there's a strategic advantage to the timing of filing that particular motion. Say there's a deadline for expert witnesses to be designated, and one of the ways that you could challenge either side's case, aside from perhaps if they've designated some experts but have left off other areas where they need an expert, is to wait until after the time expires for the other side to designate their expert, then bring your motion to exclude, or if they've designated experts late, a motion to strike. And then quite often what happens is, in conjunction with those kinds of motions, parties bring a motion for summary judgment so that you can kind of stair step it, where if you win on the expert issues, the other side can't prove their case, and therefore the client, the party who files the motion would be entitled to summary judgment. And so there can be a really sort of a stagger effect to some of these motions, and that is the idea that I'm getting at when I say timing and subject of motions. Okay, now we're going to pick up and move on to the slide that's captioned Motions, Responses, and Trial Briefing. As I think I indicated earlier, this is what I think is one of the most effective ways of an appellate lawyer, or for an appellate lawyer, to get involved in matters in the trial court. And I've got listed out some different stages and activities in the slide that the appellate lawyer can get involved in. First, of course, is pretrial motions, motions to dismiss, which are frequently involve jurisdictional issues, or things like pleading defects that require a fair amount of legal analysis. You're applying the same types of skills that you would in an appeal, and looking at jurisdictional issues and that sort of thing. And then, of course, one of the major areas where an appellate lawyer can get involved in a trial court case is in preparing and responding to motions for summary judgment. You're dealing largely with legal issues, quite often with legal issues in those cases, or you're arguing about what the facts, affidavits, depositions, those sorts of things show, and whether the party who's opposing the motion has done enough to raise a genuine issue of material fact. And quite often, when the courts grant summary judgments, those are taken up on appeal, and so the basic analysis of, has there been a fact issue raised, or has the movement demonstrated their right to summary judgment, or right to judgment as a matter of law, those are things you're going to see not only in the trial courts, but on appeal later if the motion is successful. At trial, particularly in bench trials, there's often a need for trial briefing. Judges sometimes will announce from the bench in a bench trial that they're really curious about this one particular point of law, and they'd like a memo on it, or a brief on it, or the party might offer to file a brief on that issue, and the court may say, sure, go ahead and submit one. Those are frequently very short, a couple of pages, and just hone right in on whatever the legal issue is that the trial court has expressed interest in. On rare occasions, you might see that trial briefing come up in jury trials. It does happen, but in my experience, it comes up more often in bench trials, because the judge doesn't have to be concerned about saying any of these things in front of the jury about what they're wanting input on, although they could excuse the jury. And it just is something where there's more of an ongoing exchange with the trial judge than what you see in the ordinary jury trial, because the judge is not only the arbiter of the law, but also of the facts. And so another area is in various factors surrounding the judgment. If you've ever been involved in crafting a judgment, it can be a very technical process. Different jurisdictions have specific requirements about what judgments ought to say. For example, if your jurisdiction is one that recognizes that a judgment becomes final merely by including what we call a Mother Hubbard clause, or all relief not specifically granted is denied, that can be a tricky issue to deal with because it can affect the timing of your appeal or an appeal. It can affect whether the party is entitled to relief. Another aspect relating to the crafting of the judgment is to make sure that it covers all the claims and issues and parties. And I was just speaking about finality a moment ago. When a judgment, if a party gets what it thinks is a final judgment, but it's not really final, it can delay the process of taking an appeal. If a party gets what it thinks is not a final judgment, and it really is final under the law of your jurisdiction, then you could wind up in an awful trap of the timetables starting to run on the ability to appeal that judgment. And I have seen plenty of cases in Texas law where a party lost their appellate rights because they didn't appeal what wound up being a final judgment according to the law within the time required. So, different jurisdictions have different requirements for what judgments should contain. You have to familiarize yourself with what your jurisdiction calls for, and then it is, I think, an extremely useful thing to a trial lawyer to have someone who knows, who's educated about these issues, who knows, for example, what the pre- and post-judgment interest rates are, or knows easily how to find that information, and knows how to calculate a judgment, which can be a little tricky, particularly when you're talking about actually calculating out interest. It helps to have an accounting background and being able to calculate either simple or compound interest in that situation. You can go outside of your own knowledge to have people run numbers for you, but just even to know all the elements that go into it and how they all fit together is a big service that you can offer to trial lawyers. And then what we normally think of as motions dealing with post-trial or post-judgment issues are things like motions for judgment as a matter of law, motions for judgment NOV, non obstante verdicto, or motions for new trial. And these can be much like summary judgments in that they can deal with disputed issues of law or fact as applied to the case, and can be potentially case dispositive. It's not all that frequent that a judge takes the case away from a jury, but it does happen, and you might just be in one of those situations where a court may be inclined to do it, or may be inclined, if the jury comes back with a verdict that doesn't seem to comport with the evidence that's been presented or the arguments that have been made, then you are in the position to assist the trial counsel with presenting arguments as to why number one, your client, if they're on the right side of this issue, should be entitled to judgment as a matter of law, and maybe the case doesn't even get submitted to the jury, or your client, for whatever reason, the jury's verdict ought to be set aside and a judgment rendered for your client despite the outcome, despite what the jury has done. And then, of course, motions for new trial. If the trial judge is not inclined to grant either one of those types of motions, then a motion for new trial might be appropriate, although the primary use for a motion for new trial, and to some degree for the other post-judgment motions as well, is to make sure that you've got error preserved. And we'll talk about that a little bit more in a minute. And of course, another area that I think is somewhat overlooked in terms of ways for appellate lawyers to get involved at the trial court level, this sort of assumes that you've been involved leading up until this point in the case, but assisting in preparing findings of fact and conclusions of law for the court can be critically important, generally in bench trials. Most of the time this is not necessary, and it may not even be appropriate in a jury trial unless you've got some gap in the jury's findings. But in bench trials, and maybe not even necessarily a trial, and some hearing, for example, on what we have in Texas as a special appearance or maybe a venue issue where there could be a right of appellate review right after this ruling, it is useful to analyze what would be a good set of findings of fact, or what facts do you need the court to find to support your position on those issues. And there's an opportunity for advocacy here, because if you're going to be the party challenging the findings and conclusions, you have to be kind of careful with how you do this, because you don't want to be seen as agreeing with what these findings are. But what you have the ability to do is to make sure that the trial judge covers all the bases, makes all the findings necessary under the theories that have been pleaded, so that there's no gaps and there will be no possibility of what we in Texas call deemed findings, which means essentially that if the court doesn't make a specific finding and the judgment is such that it supports the judgment on the theories asserted, then whatever the court left out will be basically assumed to have been found, and it can get more difficult to challenge judgments based on, from jury trials, when there's either no findings or conclusions or there's an incomplete set of findings and conclusions, because as the appellant you're always going to be fighting the uphill battle, and so you want to make sure and preserve or position the case as best you can for appeal, and one way to do that is to make sure that the findings and conclusions are complete. And of course, from the prevailing side of that issue, you don't really have to worry about deemed findings. Generally, if you've prevailed and you're trying to just get a judgment, and the judge has asked you as a prevailing party, for example, to prepare findings and conclusions, you have the ability to craft those in a way that supports the judgment in the best possible way, and present what you would prefer to be findings that the court would make. From the losing side of that issue, you can do that too, although the chances of the court announcing a decision, going back on it, and making a finding that's completely the opposite of what the court has announced on the record are not very good. So findings of fact and conclusions of law are sometimes overlooked as a way to, as an opportunity to try and either persuade the trial judge about a certain shade of a finding, or certainly this is a way that an appellate lawyer can help get the case ready for appeal, is by making sure that in the situation where they're warranted or where they're called for or where they're necessary, that appropriate findings and conclusions are made, and that puts the appeal in the best possible position going forward. All right, the next slide talks about error preservation, and I've touched on some of these issues a little bit earlier, but I want to cover them explicitly here. As a general matter, a party has to preserve error before it can present an argument related to that issue on appeal. So the best example of this, of course, is an evidentiary objection, and we cover that in the slide. But if you've got some just awfully prejudicial piece of evidence that you want to keep out, or that the trial lawyer wants to keep out, for that to be potentially a ground of reversal on appeal, the error has to be preserved. So you would have to object under your jurisdiction's evidentiary rules to make sure that the trial judge has the ability to exclude the evidence based on the objection, based on sustaining the objection. So error preservation is potentially an art in and of itself, because the trial lawyers are down in the ditches, in the trenches. They're in the heat of battle, and sometimes it is very difficult. You sometimes miss details about errors as a trial lawyer that it would benefit you greatly to have someone who's a little bit detached, who can observe the trial from a more neutral perspective, and who is attuned to what has to be done to preserve error in certain situations. And so it is a frequent occurrence when, in cases that justify it, for appellate lawyers to attend trials, monitor the trials, provide the legal support that we've talked about so far today, but also to assist in preserving error for appeal. And there are several avenues and several stages of a case at which this can happen. First, as I've got listed here, there are pretrial issues. Sometimes you want to make sure that certain issues don't get placed in front of the jury. Pretrial is probably the area where this is least important, other than making sure that you have pleaded all the appropriate theories, making sure that you've made the appropriate legal arguments. I think pretrial, really, error preservation comes up most often in terms of making sure the pleadings are complete and that the relevant defenses have been asserted, because if they're not, then there can be a waiver and you're not going to be able to assert an error, or that you should have been able to try the case on another theory if that wasn't raised in the trial court. Evidentiary objections, I've already given an example of that. You ought to be, as an appellate lawyer, pretty up to speed on hearsay, relevance, have a feel for the evidence that's going to be introduced at trial, have conferred with the trial counsel about whether any of the opposing side's evidence is going to be objectionable if you've exchanged exhibits ahead of time, which most cases you would have, and so you would know what the other side's evidence is going to be. And so you'll have some ability to prepare for this ahead of time, but there's always going to be something that comes up at trial. A witness is going to give some surprise testimony. A witness is going to try and testify based on hearsay. Oh yeah, Joe told me that. Those are good opportunities for you to help provide input on preserving these kinds of errors. Now, whether those errors are reversible on appeal is a completely different matter. A lot of jurisdictions have a harmless error rule, and also the standard of review for reversal based on evidentiary errors is very high. Usually it's abuse of discretion. But nevertheless, in some cases it's important to preserve the error. In other cases, it's important not to object too frequently. So you have to strike a fine balance. You have to strike a balance between making sure you preserve evidentiary objections on critical issues such as inflammatory evidence that's incredibly detrimental to your client, something like past criminal history or something like that. Balance that against making it appear to the jury that you're just objecting to everything. And so that's a strategic issue that should be discussed with trial counsel. And trial counsel probably will be the one making the objections most of the time upon your recommendation. So it's a sort of a team effort there. Jury submissions, actually I'm going to get into that in more detail in a moment, but the jury charge is a critical aspect of trying any case, and there's lots of opportunities for advocacy there. And of course, post-judgment motions, as I mentioned a few minutes ago, in a lot of cases to present arguments on appeal, they have to be preserved either through one of the evidentiary objections, or if you're going to challenge like legal sufficiency or factual sufficiency of the evidence. In Texas, and I think the same is true generally in federal jurisdictions and a lot of other states, you have to have presented those issues by the appropriate kind of post-judgment motion. In federal court, for example, if you want to assert at the end of the case that if you're on the defense or on the plaintiff's side, that your client is entitled to judgment as a matter of law, that there are no fact issues, then you've got to follow the procedure set out in the federal rules to do that. And if you fail to make those motions at the appropriate time, generally at the close of the plaintiff's case and at the close of all evidence, then the Court of Appeals is not going to review that argument, because the court is going to say you have the obligation to preserve it in the trial court or the district court. You didn't do it, and so therefore it's been waived. Factual sufficiency issues, those sorts of matters generally have to be addressed in a motion for new trial. And if they're not, it's the same problem. Ordinarily, the court is not going to review a claim arguing about the facts if the right post-judgment motion wasn't filed at the right time. And so post-judgment motions, there's going to be a lot of variation by jurisdiction, but as a general matter, they are critical to preserving error that may go up on appeal. And this is an area, mostly this is coming up after the trial, where you can sit back and do a little research and present to the trial counsel issues, having sat in on the trial and knowing what the issues are likely to be, making doubly sure that those complaints that you intend to take to the appellate court are indeed preserved for the court's review. Jury charge preparation is something that ought to be considered from day one of a case. If you don't know what a jury charge is, then before you do too much more in preparing for your career as an appellate lawyer, you should do some research on it, talk to some trial lawyers and get their input on it. The jury charge is or the jury instructions, whatever your jurisdiction calls them. It is the document that instructs the jury on what the law is in the case and asks them the questions that they need to answer to arrive at a verdict, which then the trial judge typically will take that charge, take the verdict, and incorporate it into a judgment or otherwise somehow act on it as part of its duties. And so the charge really is a critical document because it's going to determine the facts. And once the jury determines the facts, generally it's very difficult to overturn that. So a common practice, and one that actually I think ought to be even more common, is for lawyers who anticipate a case going to trial to prepare a jury charge, a draft, very early in the case to help advise them as they develop their evidence. You have the document basically presents the different theories that have been pleaded, and you ought to know more or less from looking at the draft document what you have to prove or what you have to defend against if you're on the other side of the case. And so it's really helpful in terms of identifying issues to be raised in discovery and how to develop evidence on those particular points. As far as advocacy opportunities in the jury charge, there's a fine line between preparing a charge that is very slanted in favor of your client versus a charge that's going to hold up on appeal. And what you want to try and do is prepare a charge that is accurate with respect to what the law is and what it says. But if there's any variability at all, try and sort of tilt the jury ever so slightly in your favor. And it can be a matter of just how the question is worded. It can be a correct statement of the law, but the phraseology within the question can be a way to apply some sort of very subtle advocacy to jury charge preparation and presentation and hopefully get the jury to answer the question in a way that favors your client. A lot of jurisdictions have pattern jury charges. Texas is one of those. You see federal pattern jury charges out of the circuit courts, I believe. Those are very useful tools for putting together jury charges. They generally contain the basic instructions that the various courts have approved, such as the general instructions for the jury, and then sometimes in Texas, for example, you can actually get very specific questions and instructions from the pattern jury charges tailored to specific theories. And so they're extremely useful, but they're only a tool, and they're not the be-all, end-all of preparing a jury charge. So you should not rely on them entirely in preparing a charge. Judges quite often want to see additional support for the submission of certain questions or definitions or instructions, which is something else the charge contains, is it defines terms for the jury or instructs the jury on the burden of proof, for example. The judges often want to see not only cites to the pattern jury charge, but also citations to case authorities supporting the various submissions that you're requesting. And so use cases where it's appropriate. Take advantage of the opportunities where you can for advocacy, but be mindful that if you build in what I would call it is if you build in error to the jury charge because you take it too far, then you could really wind up hurting the client as opposed to helping the client. So as I say, it's a delicate balancing act between advocating your client's position, putting the law in the best possible light for the jury to come back and find facts favorable to your client. But if you push it too far, then it might wind up getting reversed and going back for a new trial, or worse yet, possibly rendition of an adverse judgment for your client. So this is another area in which it's advantageous to keep up with recent developments in the law, knowing what's coming out of your courts of appeals or your Supreme Courts, so that you can know where the subtleties are and different shades of legal issues, and have educate yourself and be educated in a way that benefits the client and the trial lawyer, and shows them that you know what you're doing and that you know what you're talking about when it comes to these issues. And then another major area in Texas, certainly, for advocacy and a role for appellate counsel in the trial court is handling the jury charge conference. This in Texas happens after the close of all the evidence, but before the jury gets the case. The trial lawyer is generally thinking about their closing argument, what they're going to say to really hammer things home with that jury. And so having someone who's worked on the charge, who's hopefully monitored the trial and is familiar with the evidence, to actually handle this, what is often just a very short period in front of the judge with the court reporter present, making objections to what the other side has proposed or what the court has proposed submitting additional instructions or definitions, requesting those. Requesting is a term of art in Texas in jury charge practice. This alone can be a huge area where your case can be made or broken based on whether error is preserved. And again, tying this back to error preservation, the failure to object to a jury charge that winds up being unfavorable to your client, is most often going to lead nowhere on appeal, because you've got to have preserved the error. And so the appellate courts are not going to be very sympathetic, even if the charge is flat wrong on the law. You've got to have an advocate, somebody there who knows what the law is and knows how it all fits together, knows how the charge is supposed to work, and knows how to preserve error, and is able to bunch all those things up and make an effective presentation to the court to keep issues out, for example, that aren't supported by the evidence, or to submit instructions in areas that the jury is likely to be confused if they don't get a definition of proximate cause or some other legal term like that. So handling the charge conference is actually a very fertile area for involvement of appellate lawyers in the trial court level. All right, so that's sort of it in a nutshell. I could talk a lot longer on all these subjects, but I think what I would like to encourage folks to do is to, I've got the slide here for questions. Please feel free to call me during my office hours. That's what they're for. Participate in the official study group of the Appellate Practice and Procedure course. Ask your questions. If you ask them through either the official study group or the informal group that I created called the Appellate Discussion Lounge, I'll do my best to answer them. I'll either answer them in those forums, or if I have an opportunity to answer them in a course video and tie it into the course content, I'll do that as well. So I thank you for your attention. Next time, we're going to be talking in class number 3 about handling the appeal. The discussion is going to be focused on the decision to appeal and preliminary matters in handling appeals. So again, thank you for your attention, and I look forward to seeing you next time at Solo Practice University.